Hello, how are you doing? Welcome to Lawyers Info Hub. It's a pleasure to always have you on this platform. Lawyers Info Hub is a platform that was born out of passion to support the growth of legal education in Nigeria. And in Africa, we believe that with excellence, one can become whatever they believe they can. We are supporting, helping law students, young lawyers regain, the knowledge of law in the most simplified way, understand it, utilize it for their own benefit. So today we're looking at self-defense and when it will not avail an accused person. A lot of people always they are used to the defense of self-defense in itself. The defense of self-defense, if they'll feel I acted under self-defense, I acted under self-defense, but they don't even know that it's not in all circumstances that it will avail the person who is using it as a defense. Now, for a plea of self-defense, you know, to avail an accused, there are lots and lots of things that accused must prove. Now, it is only open. An accused person can only utilize the defense of self-defense if he can prove that he was a victim of an unproved assault or unprovoked assault, causing him reasonable apprehension of death or grievous harm. What this is trying to say is that if an accused person to rely on a defense of self-defense for himself, he must show that he was a victim of unprovoked assault. He was unproved assault. You can use the word unproved. Yes, it's much better. Unproved assault, which made him to be apprehensive. He became afraid. Reasonably, he became afraid, not knowing, feeling like I'm about to die, causing him reasonable apprehension of what grievous harm or death. These people will kill me, or this person will kill me, or cause me grievous harm. Now he's not entitled to use that force to defend himself as he reasonably, must not this word, reasonably believes he needed to preserve himself from danger. Remember that if the accused, in using a reasonable force, the victim or the aggressor dies, that is when he cannot say, well, in defense, I was apprehensive. I felt this person was going to kill me. So in self-defense, I retaliated, which led to his death. So it's not in all circumstances that an accused person will rely on self-defense. You must also understand that if the act of self-defense is committed after all dangers from the assailant is past and by way of revenge, someone where you were sitting down, someone came to hit you, or you saw someone coming with a knife to stab you, and out of fear, you took a stone or to throw at him, the person dies. That was in the act. Now, if someone, for example, stabbed you, or someone slapped you in the heat of an argument, and you waited a day, 2 days, the whole thing has died down, you came back to stab the person, the person died. You cannot say you acted in self-defense. It has to be in the instant. It has to be in the now. It has to be immediately. You don't have to wait until all the anger or the pains of the assault has died down. You now want to come and revenge, and you want to claim self-defense. It's not going to work. You must also, a very key thing is that for you to utilize the defense of self-defense, you must not be the aggressor. You must not be the one that was looking for the trouble. You must not be the one that aggravated the anger that made the person to hit you. You must not be the aggressor. You must not be the one who is causing the problem. You must have also acted in good faith without premeditation. You weren't thinking, not like you thought of, I need to kill this person or I need to injure this person. It should not even be born out of something you thought about. You acted on the impulse. Someone came with a knife to kill you, and in self-defense, out of fear of this person, you use a stone to hit the person. or use the stick beside you to hit the person, your action, your retaliation, your action should not be what you thought of. It should not be something you have been planning. It should be in the instant. You must act in good faith without what premeditation and intention of doing more harm than necessary. You should not have planned to do more harm than necessary. This person beat your child and you went and brought a gun to shoot at the person. You should not intend to do more harm than necessary. And the act of the disease must be sufficient to excite and accuse a reasonable what apprehension of imminent danger or grievous harm to justify appropriate disappropriate defense. What he's trying to say is that the person that died upon whom you're claiming self-defense must have acted, his actions or her actions should have incited in you reasonable fear, reasonable apprehension of they want to wound me, I'm going to be killed if I don't do anything. So there should be that apprehension of fear. It was act of fear for your life that you retaliated. It was act of fear. So it has to, it must not be said that, well, the person didn't do much. He just stabbed him and immediately used the knife and stabbed him. It is not commensurate. Stabbing and stabbing has no correlation. That someone was trying to stab you and you overpowered him and pushed him and he hit his head on the floor or the stone and died. It's commensurate. Not when the person just maybe jokingly tapped your head or tapped your ear, and the next thing you are stabbing the person. The action of the person in tapping your head does not excite any fear of I'm in imminent danger, I'm about to be wounded grievously. So when an issue of self-defense arises, the failure of the accused to retreat when it was possible and safe for him to do so is simply a fact to be taken into account in deciding whether it was necessary for the accused to use force and whether the force used on him was necessary. Now, the court also look at, why didn't you run away? Was there a possibility of you leaving that place? Was there a possibility of you, escaping that moment? Why didn't you run away? Was it safe? So the court will take into account those circumstances. Was there a possibility for you to have run away and the accident couldn't catch up on you? Is there a possibility for you to leave that scene? These are the possibilities the court also look at. Was it necessary? Is there a possibility that, okay, someone was about to hit you, overpower and run away rather than pushing him to die? The court will also look at all those things. Now, it's also possible the court also look at where in the circumstance of the story it was said, or the court could see that the accused was able to overpower. Somebody wanted to stab you, overpowered him by, removing the knife from his hand and throwing it away or dropping it. And the court, could decipher how or the story was told, or it is confirmed, or a proof that you were able to remove the dangerous weapon or, dislodge the assailant. But rather than you to keep maybe that knife, or after keeping it, you still went to use it to stab the person, it should be taken as more of a revenge. It must be taken as an act of revenge or retaliation. Very important. I've said that this defense will not avail an accused who is aggressor, the person who initiated the anger, the assault, the person who intentionally, made someone to lose, his or her temper, the person who caused the fight. It will not avail you. Check the case of Musa against the state. It's a 2009 7 MDSC part 152. It's a explains issue of what self-defense. So in that case, the accused, he entered a class, forcing people to leave the classroom. He brought out a knife from his pocket and launched an attack, which killed the deceased. So you came to a class and were trying to push people away. You brought out a knife, and in the course of that, trying to push people away, you stab the person died. You're coming to claim self-defense. There's nothing like that. There's nothing to show that the person offended you, the person hit you, there was apprehension or fear or death grievous harm. In the course of that apprehension, you acted. There was nothing like that. So this has to be commensurate. You must understand these facts when someone is trying to say, I'm going to rely on self-defense. You're going to rely on self-defense. Were you the first? Are you the aggressor? Did you act in good faith? Did you act in good faith? The action, your action that led to the death, is it commensurate to what happened that led you to be, to do what you did? There must be the actions of the assailant must be able to excite you to reasonable apprehension of fear, grievous harm, of death. It was out of that fear you acted. Out of that fear, that is where you acted. So, friends, I just hope you'll be able to learn something from this topic today on the issue of self-defense. On the issue of self-defense, the defense of self-defense, if it's successful, it is a complete defense or an answer to a charge of murder or manslaughter. So it's also better. It's good when someone is raising it. You raise it in his defense, you know, but you must know whether the person can be able to get it. You must satisfy the prerequisites. Thank you.